Hello everyone. I hope this message finds you fit and fine. My name is Shashank Tyagi. Welcome you all to our contest series on Indian polity based on Lakshmikant. In our previous video, we were discussing about concept of federalism, how it evolved, and what kind of form of this concept of federalism was adopted for Indian polity. Today's topic, center-state relation, is an extension of previous topic. We need to understand the basis of relation between center and state. In federalism, we use the word division of power. So you can say, today we need to understand this division of power in these three heads. Today we are going to focus on legislative aspect. Okay, but in this topic we need to understand these three heads. First is legislative head, second is financial, and third is executive. In center-state relations, we don't talk about judicial or judiciary as a basis of division. The reason is, in India, we adopted integrated model of judiciary. But in case of US, they have division between federal government and state government on the basis of judicial as well. But we don't have that. We have only three areas of division of power. Okay? This division is clearly mentioned in our constitution in part 11 and part 12. And the kind of questions UPSC is going to ask, number one, there can be a statement based on some fact, part, provision, okay? Second statement could be on exceptions within the center-state relations, okay? And third can be, if there is some legal dispute going on, there are some claims made by a state that this law is not the prerogative of center. But this became a news. So one statement can be from that area. Okay. In case of mains, you can have one question where UPSC is going to check your understanding of these provisions. Second question can be dynamic, where you have to infuse your static and dynamic knowledge. Okay. There are good amount of trap questions which can be made from this topic. So if you are cautious while watching this video, I will request that now you should become extra cautious. Have a pen and paper in front of you if you can. If you are traveling, then that is fine, because we are going to have some tricks and tips also here so that these things get concussed in your mind. Okay. Now, legislative power. So these are mentioned from Article 245 to Article 255. And there are four aspects of division of legislative power. Okay, what are the four aspects? Number one, territorial aspect. Means a state legislative power is going to have extent to which territory? Center means parliament is going to have influence on which territory? Some of you might be thinking, oh, it's quite obvious. Parliament is going to have the whole of India and state legislature is going to have specific to that state territory, right? That is what you are thinking. There are three cases in this. Number one, Parliament can have this law-making power to the whole of Indian territory. Second, to a part of Indian territory. Third, beyond Indian territory. Now tell me, which of the three aspects with respect to territorial legislative making power of parliament are true? Think and just mention in comments. As of now, I have no expectations, because I am considering that you are just starting off. Okay, at later point, I am going to have expectations from you. But just answer. Some of you would say, sir, it is quite obvious that Parliament can make law for all of India or part of India. How can Parliament make law for territory which is not part of India? But my friends, answer is all three. So it means you should not take this topic lightly. Okay. Now, subjects, the division of subject between center and state that we are going to discuss when we are going to discuss Schedule 7. Okay. Today we are going to deal with legislative aspects, all kind of questions, dimensions which can be asked. Now, third aspect is Parliament's power to actually make law on subjects which are considered as state subjects. Fourth aspect is center's power to actually have control on state legislature. What does it mean? It simply means, consider that you are governor of Uttar Pradesh. Okay, no, take yourself as governor of Rajasthan, because in Rajasthan we have a Congress government. So now Congress state legislature, they actually passed a bill, and this bill has been presented to you. You are governor of Rajasthan. Okay. Now, it may be possible that you see, oh, this provision is having some conflict with center, a law made by center. And that is why you reserve this bill for the assent of Honorable President. So when Rajasthan legislature, Rajasthan CM was expecting, oh, now Honorable Governor is going to sign this bill and this will become act. But you took other course. You sent this bill to the Honorable President. And you know that Honorable President has to act on aid and advice of Council of Minister. And who is the majority party there? Who is the ruling party? BJP, right? So it may be possible they see, oh, no, this is in contravention. So now, don't you think center means here, Council of Minister, advising President, is having control on legislative power of state legislature? You can say legislative power of state, right? So these are the four aspects in which we have to understand legislative relations. I hope this is clear to you. Just remember these areas. That's it. Okay. Now, territorial extent of center and state legislature. Number first, Parliament can make law for whole of India or any part of India. Okay. Along with this, Parliament has one more power, that is extra territorial power. And this power is only with Parliament, not with state legislature. Please remember that. Okay, there are three cases of territorial law-making power of Parliament. Clear? When it comes to state legislature, it can make law for whole of state as well as for part of state. For example, Madhya Pradesh legislature may make a law which is going to be applied for only 2 districts. If conditions are such, they can apply this law for 2 districts. Okay? Parliament alone has this power, extra, territorial. When I'm using the word territory on which Parliament is having power, what does it mean? It means the definition of territory which we discussed in part 1. It means all states, UTs, as well as all the territories which are acquired, okay, acquired by India. I find a beautiful scope of question here. Just listen to me. What if UPSC make a statement that Parliament's power to make law absolutely extends, Parliament has this absolute power to make law with respect to whole of territory of India, which include all states, all UTs, and other territory which may be acquired by Indian state. Now tell me, the statement would be true or false? And mention in comments. Those who are watching this video, just mention in comments. Should I repeat? I'm saying Parliament has this absolute power to make law with respect to whole territory of India, which include all state, UTs, and other territories which may be acquired in future. The statement is true or false? Come on, in comments. Because my purpose is to actually reduce any scope, eliminate any scope of you marking wrong answer in exam. And that is only possible when we actually have maximum accidents within this class through these trap questions. So some of you might be thinking, sir, it is quite clear from the statement, can make law for whole or any part of India. So whole means whole. Statement should be true. And 98% students who have read this chapter for say 1 or 2 times and missed on understanding the detail, the intricacy, will mark wrong. Because answer is not true. Answer is false. Because the word absolute was used in the statement, absolute power. एब्सोल्यूट पावर नहीं है. Okay, because there are exceptions, and within the start of the video I told you that UPSC will play on these exceptions, and we are going to cover this, all of this, don't worry. But answer is no, and answer is no because absolute power is not there. There are exceptions as well. Okay, what are those exceptions? Let it be a bit of suspicion there. Okay, not suspicion, suspense. Okay, now laws of parliament are also applicable to Indian citizens and their property or any part of the world. That is a part of extraterritorial. There's a famous case in here. Wallace versus Income Tax Commissioner, 1948. Okay, this is related to extraterritorial legislation. So what was happening in this case? There was an England-based company, and this England-based company actually made a partnership with an Indian company. Okay. So now, Income Tax Commissioner sent a letter to this England-based company that you have minted majority of profits from India, and you have partnership here. So that is why my assessment says that you have to give this additional amount as income tax, in this case corporation tax. So as a reply, this company said, no, you are using a law which was made by Indian Parliament. This law is not applicable in my territory. Now judgment came, and judgment said, if there is territorial nexus which can be established, it means the claim which Indian state is making in other territory is connected to Indian territory. Then in this case, yes, this England company has to pay this additional tax to India, because as per Indian law, the tax is right. Okay, but you have to do this test of territorial nexus. I hope that this is clear now, right? So in this case, what is happening? Extraterritorial legislation is in place, right? This law is being applied to other territory also, right? But this power is also not absolute. The test of territorial nexus should be made, right? Now what are the restrictions? I told you, exceptions are there. Just take a look over these exceptions. President can make regulations for peace, progress and good government of 4 union territories. It means the laws of parliament not applicable in the following areas. And in which area? These are the area. When I say area, it means peace, progress, good government. In this case, president's regulation will supersede any law which is made by parliament. And I find beautiful scope of question from there. Now, it is quite easy to remember which UTs we are talking about. It is not applicable to all UTs. Please remember. Only applicable to Lakshadweep, Andaman and Nicobar and D square. D square means Dadar and Nagar Haveli and Daman and Diu. Okay, Dadar and Daman. Clear? So there are 4 areas which can be considered as exception where president's regulation will supersede a law made by parliament. Important, I would say. So when UPSC asks this question and you answer it correctly without falling into trap, then you can connect with me at later stage. Yes, sir. That advice actually worked. Now, second case. The governor is empowered. So governor is empowered in what context? In context of scheduled areas. So what can they do? It can direct that an act of parliament does not apply. So even if a parliament has made a law that I am parliament and this law is going to be applied in whole area, all the territory of India, then governor for some state may actually present a regulation, and in that regulation governor will say no. Even if this is a parliamentary law, but it is not going to be applicable in the scheduled area. Okay, so it's a limitation on the you can say application of law of parliament, right? Third, in case of governor of Assam can do the same thing for tribal areas. Okay, apply to tribal area, or you can say autonomous district. So why we have this separate point 3 here? The reason is the provision of autonomous districts are there. There may be a case that there are scheduled areas, but in these scheduled areas, we have not given them autonomous power. Okay, so in that case, you have to apply article with this subclause 2. Here, point number 2. But it may be possible that due to the demand of these tribals, we have given them autonomous district status. It means when you become a civil servant and you are posted in this area, so you will have a district council. You will be having the core authority, but to support you, there will be a member from this tribal community. Okay, so this is a step towards inclusiveness. Okay, now another is president enjoy the same power with respect to 3 states. Please remember Meghalaya, Tripura and Mizoram. You can remember MeTM. Clear? I hope it is clear. Please remember these exceptions. Nowhere I have mentioned, in this case I have not mentioned Arunachal Pradesh. I have not mentioned Nagaland. Okay? Although these areas, specific areas, say scheduled area, they can be covered by the governor. But in case of that, the power of governor is there to supersede a law made by parliament. But in this case, in the case of 3 states, president enjoys this power. Okay? Now, distribution of legislative subject. So first was territory, second was subject. So now we are at subject. So there are 3, you can say, list in schedule 7. Union list, concurrent list, state list. Union list, which is the, you can say, the largest list having 100 matters there. Concurrent list means in these areas, state and center, means union and state both can actually make law, right? And the state list in which a state legislature is going to have power. What kind of questions you can expect? Just go through the subjects on which union has power to make law. But don't think that UPSC wants you to remember all 100, 61 and 52 subjects mentioned here. No, there's no need. If a question is asked on match the following or a statement mentioning that this is a prerogative of union, this is mentioned union list, then UPSC might ask question only on those subjects which were very much in news. For example, in COVID times, health management was in news, right? So who has the major responsibility to take care of the public health system? Is it center or a state? It becomes a topic. Education, citizenship due to CA. So it means UPSC wants to check whether you are aware and whether you are interested, curious enough to connect the current happenings with the, you can say, structure which is mentioned in Indian polity. Okay, this is the approach which they are looking for, as per my analysis in past, around 7-8 years. Now, the power to make laws with respect to residuary subject. Now, what are the residuary subject? It means those subjects which are not mentioned in any of these lists. So, in this case, the power will come to union. Okay. In case of concurrent list, if law is made by both union and state, what is going to happen then? If there's a case of repugnancy coming new, means union and state law coming into conflict, then in this case, law made by union is going to be considered superior. Okay. But there's a you can say twist here. Some students, when they read Lakshmikant and they see, okay, in case of repugnancy, union law made by parliament will supersede. But on practical grounds, we have so many examples. This led to a conflict which was heard in Supreme Court, and Supreme Court used this doctrine of harmonious construction. Means Supreme Court made an interpretation by which both laws can work. Conflicting provisions were interpreted in such a way so that this conflict can be diffused. So such thing also happen in practical terms. Okay. Now, if we compare Indian division of legislative subject in center state with, say, USA. So in US Constitution, there's mention of federal subjects. And since just federal subjects are mentioned, what did it signify? The interpretation is that residuary power lies with state. So there, residuary power lies with state. Any matter which is not specifically mentioned, state is going to make law. But any matter which is not mentioned, union is going to make law in context of India. And with Australia as well. In case of Australia also, this residuary power lies with provinces, means states. Okay? So there is a difference. Now, this is fact that union list 100 subjects, state list 61 subject, concurrent list 52 subjects. Okay? Both parliament and state legislature can make law on these subjects. I'm talking about concurrent list, I told you. But in case of conflict between union and state, regarding subject, union law prevail over the state. I've just told you. And I also added one practical example of doctrine of harmonious construction. Now, third aspect is parliamentary legislation on the state field. Okay? What we are doing actually, we are going with the structure. I told you there are 4 aspects. Out of this, we are on third. First, second, now we are on third. Means parliament having say on the legislative power of state legislature. So how can this happen? In this case, Rajya Sabha's role come into being. Because Rajya Sabha represents state interest. It is considered at least. So the constitution empowers the parliament to make law on any matter in state list. Please remember, any matter in state list. But what the condition is? 5 extraordinary circumstances. In 5 extraordinary circumstances, please remember, parliament can make law on any matter in state list. Number 1, when Rajya Sabha passes a resolution in this regard, means there's a matter of national importance and this is in state list and Rajya Sabha says, I am representing state in parliament and that is why we are conducting a resolution and we are passing this by special majority. Special majority means 2/3 of present and voting in this case. Okay, so then resolution remains in the force for 1 year. It means any law which is made in this regard, means which is made on matter mentioned in state list, will be in force for at least 1 year. But it can be renewed any number of times. Please remember, any number of times. UPSC play on these things any number of times. Okay, but it should not exceed 1 year at a time. For example, if you have made a law based on matter mentioned in state subject, then it will apply for 1 year. After 1 year, you have to bring this resolution again and then extend it for another 1 year. And you can do this process any number of time. Okay. Now, laws cease to have effect on expiration of 6 months after the resolution has ceased to be in force. Which resolution we are talking about? This resolution. Because consider this resolution was extended to 1 year and 1 year extension is say 1 January 2023. Right? On 2023, this 1 year of this resolution will complete. Okay. Now, Parliament has a choice whether to extend this resolution, but they have not extended this resolution. Now, from 1 January 2023 to 6 months, just for 6 months, this particular law will be in place. Okay. Although it can be repealed before that as well. Right? But if it is not repealed, it can actually go on for 6 months and after that it will be considered expired. Okay, this is the meaning of this particular statement. I hope it is clear now. So this is the first case, first extraordinary circumstance. What is the second? Second is during national emergency. Okay, laws become inoperative on the expiration of 6 months. So it means if national emergency is in place, now legislative power of state comes to the center. Because now it is a matter of, sovereignty, integrity of India becomes topmost priority, right? But as emergency is done, after that, till 6 months, this will be in operation. These laws can be in operation, and after that, they will cease to actually, exist, right? So now, are you observing that although power is given to Parliament in extraordinary circumstances to make law on state subject, but our constitutional framers have given some safety wall also, right? So that states' power remain intact, so that concept of federalism can be visible in Indian polity. Okay, because independence of state is being ensured by providing these safety walls. Now, when states make a request, what does it mean? If two or more states request that Honorable Parliament, we want you to make law on this topic, although this is a matter of state subject, but we want you to make law. So in this case, what Parliament is going to say, okay, if you are willing, then we are going to do that. So in this third case also, law enacted and applies only to those states, not to others. Okay, because 2 and 3 states came, right? They may be states which are ruled by the same party which is in power in center, right? So it is not going to be like 3-4 states ruled by the same ruling party in the center. They come and say, sir, make law on state subject as well, and now Parliament is empowered to make law for all the states. No, it is going to be applicable only to those specific states. Any other state may adopt it by passing a resolution to that effect in their legislation. Okay, that is their raza. वो उनकी रजा है. If they want, they can do that. Okay. Fourth, to implement international agreements, for example, Geneva Accord, Vienna Convention, TRIPS, trade-related intellectual property rights. So when we apply these international agreements, sometimes what happens, some aspects are mentioned in state subject, for example, related to trade. So in that scenario, Parliament can say that although matter is in state subject, but to uphold this international agreement, we are making this law and this will be applicable. So this will be applicable. Okay. Fifth, during President rule, a law made by Parliament continue to operate. I'm talking about Article 356, right? If constitutional machinery is broken and on this basis President rule is imposed, so now Parliament will make law in this regard. So although rule is President rule, but Parliament will actually make this law. Okay, but it will be there. And consider that after say 1 year, President rule ceased to exist. So this law, which was made by Parliament for this particular state where President rule was imposed, will continue. And continue till what time? Till it is removed or altered. Such a law can be repealed or altered or reenacted by the state legislature. But after this President rule is removed, now power will come to state legislature. Now this will be choice of state legislature. Okay. So there is no case of this 6 months expiration. Okay. Now just attempt this question. When the legislature of 2 or more states requests the Parliament to enact a law on matters of state list, that law repealed or amended by state legislature, amended, repealed by Prime Minister, amended, repealed by Parliament, amended or repealed by Governor of that state. This is a good question because in our discussion, when we are talking about the case of 2 or more states requesting Parliament, so we just discussed that yes, Parliament can make law in this regard and this law will be applicable to these states. But what about power to amend law, power to repeal law? So if law is made here and it is applicable to these states, now power to amend this, change this law, will be with these states or will be with Parliament? Right, this is the question. Although they have requested this, they want this law to be applicable for them. Does it mean that they have also given up the power to amend and repeal that law to be applied on them? Or just mean that they just have asked Parliament to make law and the later function of amendment and repeal they can do? So this is, I find this is a beautiful scope of question. What do you think? Mention in comments. Answer is C. Why it is C? Amend and repealed, power will be with Parliament because Parliament has made the law. When you have requested Parliament to make law in this state subject matter to be applicable to you, at this point of time, you have given up your power with respect to that subject, with respect to that law. Okay? It's not like you cannot make any law on that state subject now. No, you can make other law. But for that law, Parliament is going to have power. Okay, I hope you like the twist. Now, center's control over state legislation. As I told you, certain bills, reservation of certain bills to by the governor for the consideration of honorable president. Gave you the example of Rajasthan. Certain bills require prior presidential sanction. So in this case also center has control because president is going to act on aid and advice of council of minister. President can direct to reserve money bills and other financial bills during financial emergency. So in this case also president is actually having control on state's legislative power, right? So I hope now all these 4 points, 4 areas of legislative aspects of center-state relations are clear in your mind. They should be contests now. Please let me know in comments if these efforts are adding some value in your preparation or not. Okay, so this PDF will be available in Shashank Tyagi for you Telegram group. You can connect with me on Insta and Twitter also. There's my personal handle also, shashank.powerbeing on Instagram. So on weekends I connect with all the students or the doubts they ask. So see you in the next video then. Take care.